25M2621.
Your Honor.
Good morning.
And I've filed motions for competency evaluation.
Right.
I filed an objection to that, Your Honor, as well as a statement. Within that motion, it should be quite obvious that I am competent to understand the current charges, what the problems were getting here, and my actual intent for asking about the Sixth Amendment. I simply can't plead to something that's so broad. I'm not guilty of creating every act of harassment. I need something specific that I did. I do admit there could have
So,
been
Mr. Frederickson.
a lawful thing I was doing and an unlawful thing I accomplished in doing it.
Mr. Frederickson. So here's the situation. You can voluntarily go to the competency court, get evaluated. That will give us some assurance that
I understand the
Let me
implications.
finish.
Yes, sir.
Let me finish, because let me be perfectly clear. What's evident from your filing, Mr. Frederickson, is that there is a problem. And so based on that and your attorney's motion, I think it's appropriate that you at least go to the competency
If I
court.
may rebut, Your Honor.
You already have. So
haven't been
here's
able to finish it.
where we're at. Let me just.
I've spent 120,
Mr.
or excuse me,
Frederickson.
162 days, Your Honor, already under these charges, and I can't even get a Sixth Amendment
Mr. Frederickson,
understanding here.
let me just,
And if there's a problem, it's the Sixth Amendment.
let me.
Because I'm willing to plead right now guilty if the prosecutor can bring what I had actually done. I'm
Quit
willing in order to plead guilty right
interrupting
now.
me. Quit interrupting me. Just go back to the podium and listen. Now, you can either voluntarily go to the competency court intake. We'll do an evaluation. We'll see what the results of that are. And
That
if
normally takes 10 weeks or more.
it's not going to take that long. It's not going to take that long. The alternative is that I make a finding that you're incompetent, and then I order an evaluation. The competency court process is really designed to deal with things more expeditiously and fairly. But if you don't want to do it that way, we'll do it the hard way. But it's going to be
I'll
one of
happy
those.
to voluntarily prove myself. I believe I already have. However, I did leave
I
a
understand,
question.
but I disagree with your belief.
Ma'am.
Mr. Frederickson,
Only
do
two
not
of us had
talk to
read the
her.
police.
Do not
report,
talk to
Your Honor.
her. You are represented. She's not allowed to talk to you.
There's only two of us that's read until today. Now she has read the police report. I wouldn't mind her
Frederickson,
input on it.
She's not allowed to talk to you. You are represented. So you are willing to make this appointment on April 23rd at 1:30?
April 23rd. What day does that fall on?
That falls on a Thursday.
At what time, sir?
1:30.
Now, would that be the clinical evaluation or would that be
That's
a,
just a setting in Division 3A. And then they'll work with you to set those things up.
the other part of my motion, Your Honor, I would like to have an attorney I can communicate to. I was able to talk to her for 2 minutes prior to this hearing and was able to convey exactly what the issue was, where I couldn't get 1 minute in with her on a 5-minute phone call that was
Well,
supposed to
do
be
you
canceling our consultation. So I haven't had any representation yet.
Do you see all these people in this courtroom?
Yes, Your Honor, I do. And I'm
Well,
very
she's
conscious
got a
of the
lot of
fifth
clients
plaintiff
she's
court.
got to deal with. Right? So just make sure that you're doing everything you can so you're available for her to communicate with.
Should I inform the court now that I'm already in counseling? That I had to go back to counseling due to Frederickson versus Orlando out of Illinois? That was me.
Okay.
And quite honestly, Your Honor, I feel
You know-
those conditions are arriving the second time, and that's the reason why I have approached the bench the way I have. The way that I have behaved is proactive, not a harassment. Okay, not intended as being a nuisance either.
So you don't need to inform me of anything. If you're okay with
As
this
long as we're on the
approach,
record, Your Honor, I guess I have to deal with it.
we're on the record.
I'm very familiar with all the points of view here,
Okay.
and I understand yours. I mean, it's the safest plausible way in order to continue if the prosecutor wanted to continue. Absence of the prosecutor, it goes back to you. And I
So
have, objections here. Now, the only other question is, will I have a different lawyer?
you actually will in competency court. But if you come back, you'll get the same lawyer. In other words, if it's not resolved in competency
Well,
court,
whatever time that we're coming here and it is resolved in competency court, just as a reminder, we're back here and the only two, as of the time that that motion was filed, was me and you that actually read that record to show that there was no intent. So we're going to be right back here with the same Sixth Amendment problem. Someone's going to have to tell me what harassment I did. As soon as that is, because that's so broad, I could spit in someone's face. It could be a disorderly conduct involved. There could be a lot of other things involved. I have no particulars to that. And again, the only thing I brought that up with is because normally it would prompt the prosecutor to just simply talk to me informally, and this matter would have been settled because I would have pled
Sure.
guilty if there was anything to it.
we are
I'm
continuing
just giving-
this engagement.
Being my honest.
Okay, but we're done.
Okay.
Okay,
And,
April 23rd at 1.
Is there any way of pre-check-in for this, or is this all automated for
No,
me?
no, they'll know you're coming. They'll expect you. We'll even have you sign a notice for it so that you.
That's fine.
Yeah,
And again, I'm not trying to be a problem. It's too basic of something not to hold on to.
Mr. Frederickson, it's okay. We're just gonna make sure it's done the right way.
If we could pass Mr. Huggenberger for a moment, I just still need to chat with him briefly, but I am ready with Mr. Isnard.
Yeah, People's State of Colorado versus Levi Isnard, 26T118.
This copy too, so it's good, but like.
Did I say your name correctly?
Yeah, it's just to acknowledge that you got notice, Mr. Frederickson.
Good morning.
All right, looks like we've got a counter plea here for no proof of insurance